Okay, hey everybody. Been looking forward to this live stream that we'll have this evening. It's just a popular topic, and I really limited this live stream to what the title says: avoid the nursing home forced spin down of savings and investment accounts. Wanted to start with something that was relatively simple that people could kind of grasp the information, grasp the strategies before we get into some of the more complicated assets that people want to protect, like retirement accounts, like even their home. It can get really complicated for reasons that I'll explain on this live stream. So mainly, it's going to be limited to you have savings, you have a couple $100,000 of savings. It doesn't really matter what the amount is. Maybe you have an investment account with some stocks, bonds, mutual funds. We'll talk about and those things are really I don't want to call it easy, but easy for people to protect. So anyway, we'll get into a lot of that. Hey, Larry, good to have you as always, and hope you feel better. Feel free to throw things to the chat. Hey, Brenda from Missouri. So the way this works is I have some information that I'd like to share that's relevant to the topic for the evening, and then we'll jump over to the chat. So if you have a question, try to be as thorough as maybe reread it before you hit the send, just to make sure there's no missed words or you don't make it too hard for me to really understand what you're trying to ask. But we'll go to the chat once we finish up our presentation here. So, like I said, this is one that is a topic that many people are really interested in it, and most of those many people don't really understand the rules and the strategies that are available and all of the corresponding tax consequences and inheritance consequences. So I hope to lay a lot of that out for you. And one of the reasons I want to make this live stream and have it on YouTube is that so many people come to me and they say something like, Paul, I want to protect my assets. And I kind of cringe a little bit when I first hear that, because I know I'm likely in for a lengthy conversation. I don't know what they're going to do. I may be thinking in the back of my head, why are they even asking about this? But when somebody just says, hey, Paul, let's protect my assets. And I'm like, oh boy, now I've got to educate a lot of people or I've got to educate this individual or this couple. We've really got to talk about the rules so they understand them. We need to talk about the planning strategies, how that affects what you can control, and how that affects your taxes, and how that affects your children, and how that affects your potential Medicaid eligibility, and what all of that means. Sometimes we have that conversation, and rightfully so, because of some of the limitations put on this Medicaid eligibility planning. That prospective person just says, oh, never mind. And quite frankly, when they say, never mind, let's not worry about Medicaid eligibility for myself, I kind of go, whew, because I probably agree with them and think that them trying to maneuver their assets around so that they have less than $2,000 of these countable resources is really kind of silly based on their circumstances. So you'll understand what I mean by that as we go through the live stream this evening. So I want to break it down really into three parts. The first part, I really want to lay the groundwork, what we are talking about here, and really what we aren't talking about in this live stream. And then we'll hop into the long-term care Medicaid eligibility rules that exist. There's combined federal and state rules, so it can vary from state to state as long as the state complies with the general federal guidelines. And then we'll get into some of those planning strategies. Okay, we've laid out the rules. Now, what do people do in order to try to kind of protect what they have? So I mentioned earlier, I do cringe when first thing I hear out of people's mouths, because when I have a conversation about estate planning, the first thing I'm going to ask you, if you have a conversation with me, is what do you want to make sure we address? Is what's the maybe the most important thing that you want to make sure we talk about and you want to make sure you accomplish as part of your overall estate planning program of making sure all of this is easy for everyone and that you keep it in the family, you take care of your spouse, your kids, other people perhaps. What's that one thing kind of on the top of your mind that you want to make sure happens in the future? And sometimes the first thing, the very first thing out of people's mouths is, well, we want to protect our assets. Now that's a vague statement. So I already know what they're saying, but I make them say it. I'm like, oh, you want to protect your assets? Well, what do you want to protect them from? And then they start kind of nudging toward the answer. Well, Paul, we want to protect our assets. One of us might get sick. And so, yeah, one of you might get sick. What do you want to protect your assets from? And finally, they'll bring up they'll say the dreaded words nursing home, and or they might say long-term care. And so anyway, it's a tough topic, tough for professional advisors, because in the back of my mind, I'm like, let's really get to this real quickly. And in the back of my mind saying, I need to find out real quickly what these people own. Do they own so much that Medicaid eligibility planning isn't warranted? And I need to find out real quickly, what's your monthly income that you're going to be getting, because if you have too much income, that really renders Medicaid eligibility planning inappropriate. And then I'm like, I got to have a real quick conversation about who are your heirs, because people are going to need the cooperation of their children, if their children are their heirs, in order to shield assets from Medicaid. So I also want to be at the very beginning of this live stream. I want to call a spade a spade. So this really, we're not going to get too much in depth about the ethics of long-term care Medicaid eligibility, but I do want to call a spade and say, what most Medicaid eligibility planning is artificially impoverishing oneself in order to qualify for the government to pay for their nursing home care and for the government to provide the level of care that it provides to people who don't have a pot to pee in. Excuse my language. So there's an ethical discussion there. I'm not here to have it, but really that's what Medicaid eligibility planning is. And if those words scare you and you want me to say it a different way, or you feel like it shouldn't be said that way, let's be happy to see your opinion in the chat. But really, Medicaid planning is artificially impoverishing. That's the two best words I can use to describe what Medicaid eligibility planning is. And I'm not here to say what's right or wrong. There's a path. There's a lot of people who go down this path and say, I've got no problem with it. I've paid my taxes. I've saved my money. The government is going to pay for people who never save anything and have nothing. The government's going to take care of them. And so why shouldn't the government take care of me, because I have sacrificed and worked hard and saved? So there's a path of people, and maybe there's merit to that saying. And then there's another path of people who are saying, well, because I've accumulated some assets and because I have some resources, I don't think it's really appropriate that I do get all of these assets out of my name so that the government will pay for my care in the future. So some people think one way, some people think another way. If you've got a strong opinion on it, feel free to throw it in the chat and we'll get to you towards the end of the live stream. So a couple of other points that we're not going to get in depth with on this live stream. We're not going to talk about long-term care insurance planning. So I spoke with a couple today and they said, we're interested in protecting our assets. Oh, by the way, Paul, we have long-term care insurance planning. So that often, for reasons that I'll probably get into on this live stream, renders Medicaid planning inappropriate. We're not going to talk too much about as some people call it, protecting the home and Medicaid's estate recovery rights that they have when a Medicaid recipient dies. That's a bit of a complicated area, particularly when we talk about the home and preserving the step up in basis in the home when the Medicaid recipient dies. preserving the homestead exemptions, preserving the Internal Revenue Code, Section 121, exclusion of $250,000 of capital gain or $500,000 of capital gain if you're married and you sell your home. That's really going to need to be a whole nother live stream, but I'll touch on the home as I go through this, so you'll at least understand there are issues out there. I'm also not going to talk too much about the particular income rules. We're going to talk primarily about asset rules, and that's why I talked in the mentioned in the title. It's about avoiding the nursing home forced spin down of savings and investment accounts. But know that if you do have income, and by income, the two biggest sources of income that people who are worried that they're going to lose assets if they go into a nursing home, their biggest sources of income typically are Social Security income. And there's a lot of people out there still getting a pension, a monthly payment for life. That's another source of income that Medicaid looks like. The quick and dirty rule on income is, especially the quick and dirty rule for an unmarried person, is if they do have income like Social Security and pension income that you just can't get out of your name, even if you have no assets, or you're going to have to apply all of your income towards your care. And then if perhaps you pass this asset test that we'll be referring to in a moment, then it's likely that Medicaid would pay the difference between the income that you have and the cost of your care. So income's a factor, but if you have a lot of income, that makes Medicaid eligibility planning less appropriate, since your income has to be used towards your care anyway. So a lot of issues out there that we'll focus on in other live streams. I'm just starting with the basics. Don't want to get too much in the weeds on too many topics, but what I'm going to share with you is a good starting point. So what we are going to talk about on this live stream is what are the rules as they relate to things that are in your name, like bank accounts, like brokerage accounts, like stock, like bonds, like mutual funds, other investments. Even, I guess, you could apply similar. I'm not going to talk too much about rental property or real estate that's not your home, but I'd say you could say that those assets fall into this same category of bank accounts, investments, savings accounts, CDs. And again, particularly when those assets are not part of your retirement account or in your IRA. I'll focus on the IRA at the end of the live stream as one of those kind of unique assets that Medicaid has its own set of rules, and each state has its own rules as to whether or how much you're penalized if you own an IRA, traditional or Roth. Okay, so all that being said, that kind of lays some groundwork. Let's start talking about just the basics of what are the long-term care Medicaid eligibility rules. So, why would somebody want to know that? It's because if someone needs to enter a nursing home, they get at that point in their life where their health deteriorates. Maybe they have severe rheumatoid arthritis. Maybe they have some dementia. Maybe they broke their hip and they just can't take care of themselves. They can't even function enough to live in a private pay assisted living facility. They need that nursing home care. And the way the system is at a very basic level is when someone is required, does need that nursing home care, then there's a determination made as to whether that person would qualify for Medicaid to pay for that nursing home care. Nursing home care varies from state to state and from city to city around the country. If you have some good, solid personal experience because perhaps your spouse or your parent is in the nursing home and you're either writing or seeing them write a check every month for private pay nursing home expenses, throw that number in the chat. So if you got somebody from Cincinnati, I'd like to know, what does it cost in Cincinnati for nursing home care when it's private pay? What does it cost in California, New York, Florida, Texas? So throw that in the chat so, again, everybody can be more knowledgeable. But the reason Medicaid eligibility planning is such a big deal is that, yeah, it makes the difference between perhaps having to spend $12,000 a month if you have it versus not having to spend $12,000 of your own money every month, month after month, for months or years, or potentially even decades in a nursing home. I know it's unusual, but my grandmother lived in a nursing home for 20 years, from the age of 80 to the age of 100. I know you statisticians will tell me the average nursing home stay, and I see it's around maybe 2 years, 2.5 years, maybe less, maybe more. It doesn't really matter. But I saw my own grandmother. My grandparents went in there together when they were 80, and yes, this was a long time ago, back around, I believe it was around 1980, and I saw them sell their home, use those proceeds of that sale. They had a home and they had some farm property. They sold all of that, used that to pay for the nursing home. While both of them were in the nursing home, once they used all of that up, then they qualified for Medicaid to cover their nursing home expenses, just like the system is designed to do. And but my grandmother was there for 20 years. And so, by the way, my grandmother was the only person that I know of that lived in 3 different centuries, born in 1899 and died in the year 2000. So pretty unique there. Okay. So what I mentioned was Medicaid. Kind of lost my track there for a second thinking of old mama. Medicaid, it's a gotta mention here, it is a combined federal and state program. So your state and the federal government, has this Medicaid program that they work together on. The federal government has issued all of its Medicaid rules, and they do give the states some flexibility. And as long as the states administer their Medicaid program within the rules or guidelines of the federal program, the states have a little bit of leeway, and that's why these rules can change from state to state. All right, so here's the deal. And we're not into planning strategies yet. We'll get to that here in a few minutes, but you've got to understand the basic rules before we can talk about what can you do and what do people do. So when someone enters a nursing home and they desire to have Medicaid cover that, let's call it. It can vary from state to state, but let's call it a $10,000 monthly nursing home expense. So when someone enters a nursing home because they've reached a point in their lifetime, they can't live on their own. The doctors have determined that they need that nursing home skilled care. Then if that individual who's going into the nursing home applies for Medicaid or would like to be eligible for Medicaid, they'll complete a Medicaid application. On that Medicaid application, they're going to be required, and usually when 85-year-old grandma goes into the nursing home, she's not the one completing the Medicaid application. Usually someone is completing it for her, maybe her son or daughter or somebody else. But anyway, on that Medicaid application, there's lots and lots of questions. The application is many, many pages long, but essentially that individual is required to disclose all of the assets that they own. They have to disclose all of the income. They have to disclose if they had transferred any assets out of their name in prior years. And so Medicaid and Medicaid, the government has the right to look at your tax returns and take an inventory of your safe deposit box if you have one. And you don't want to lie on a Medicaid application. You don't want to commit Medicaid fraud. So I know, I've talked to so many people in the past who said, hint, hint, Paul, I buried the money in the backyard, hint, hint, or can't, if I'm about to put my wife in the nursing home, can't I stuff all my money in the mattress? Wink, wink, Paul. Not having any part of those conversations. So you want to make sure you're above board on all that. So Medicaid takes a good hard look at all of your assets as well as whether you'd transferred any assets out of your name in previous years. I'm going to call those uncompensated transfers. An uncompensated transfer is you wrote your daughter a check for $100,000. An uncompensated transfer is you sold your son a piece of land that's worth $200,000, but you sold it to him for $30,000. That's a $170,000 uncompensated transfer, and that has Medicaid eligibility ramifications. So once that full inventory of assets is declared, Medicaid essentially categorizes all of your assets into two different categories, what I call exempt assets and countable resources. Exempt assets are assets that Medicaid says, yeah, you can own this list of exempt assets, and those assets are not going to count for purposes of whether Medicaid will pay your nursing home expenses at this nursing home. The two main exempt assets that people have when they enter a nursing home typically are your home and a vehicle. Are there other types of other types of exempt assets? Yes, tools in your trades, some personal items, a burial contract. So yes, there are others, but the main things that have a value that are exempt assets are a house and a car. Now there's limits on the value, the fair market value of the house that is exempt. And you know what? I probably should have looked it up right before we started. I think it's somewhere around $700,000. So to the extent you have a house that exceeds the value of it exceeds that, whatever that limit is, then you got a problem with Medicaid eligibility. So, but let's just say for now you have a home, it's worth $400,000, and that's under the qualifying limit, so that's exempt. You have a car, it's worth $25,000, that's exempt. And then other assets are what's called countable resources. These are the things that if you have too many countable resources, you're ineligible for Medicaid. Countable resources, the typical countable resources are your bank accounts, your checking account, your savings account, your certificates of deposit, real estate that's not your home. Maybe you own some land. Maybe you own 1/4 of a piece of property that you inherited with your 3 other siblings, but your 1/4 of that property is a countable resource because you inherited your parents' property or your parents' land. Maybe you own a business or an interest in an LLC, maybe either as a partial owner or as a 100% owner of an LLC or an S corporation. Your ownership interest is a countable resource. Maybe you own stock, bonds, mutual funds. Maybe you have some Walmart stock. All of that is considered countable resources. The one that it kind of depends is your IRA, your individual retirement account. Each state treats the exempt or countable status of an IRA differently. But I will say in most states means more than 25. And in most states, it's a countable resource. So that is a big deal. I'll just go ahead and tell you right now, I cringe when somebody comes to me and they say, Paul, I want to protect my assets. I'm like, do you have an IRA? They're like, yes. Do you live in a state where the IRA is countable? Yes. What's the value of your IRA? $1 million. And I'm thinking in the back of my mind, let's just stop talking right now, because if that IRA is a countable resource, and you've got to get that asset out of your name in order to qualify for Medicaid, that means you've got to take a distribution of that $1 million traditional IRA, pay all the income tax on it, and then transfer those after-tax proceeds out of your name. Are you willing to do that? And most people aren't willing to take a $1 distribution from their traditional IRA if it's going to cause that dollar to be reported as taxable income and they've got to pay income tax on it, much less a complete distribution of their $1 million IRA. So again, I just know that sometimes quite frankly, I'm wasting time with people by having the hour-long Medicaid eligibility conversation for them to finally realize, you know what, maybe the cost of getting all these assets out of my name, maybe that's greater than just maintaining control over my assets, minimizing tax, deferring tax, staying in control. Yes, maybe the better plan would be to just keep what I have, don't artificially impoverish myself. I'm fortunate that I have $1 million IRA. And you know what? If I need care in the future, I'll just pay for it, whether that care is in my home or my children's home or in an assisted living facility or in a nursing home. So again, those are just decisions, I've seen it way too many times. Rarely, rarely does someone not interested in protecting their assets. Let me just scratch that. But anyway, I just too many times people want to protect their assets, but they're not willing to pay the cost of it, and I don't blame them. And so I kind of applaud people when they tell me or they realize, you know what, let's not do this Medicaid eligibility stuff. I'm good. So more on that in just a bit. So countable resources, the types of assets that you own that could prevent you from being eligible for Medicaid. We'll talk about the limits in a second. Bank accounts, savings, and investments, real estate that's not your home. There's lots of things out there that could have value: an extra vehicle, two extra vehicles, an extra home, an extra condo, piece of land. So all those things are countable resources. Now, how much in countable resources can you have? Well, it depends on whether you're single or married. And if you're married, it depends on whether one or both spouses are going into the nursing home. So again, the numbers can vary a little bit, but in many states, the general rule is if there's a single person, I know if you're married, disregard me for a minute if you're married, but a single person, when they go into a nursing home and they complete a Medicaid application, and if they're countable resources, bank accounts, non-home property, non-vehicle property, if their countable resources totals more than $2,000, they're not going to be eligible for Medicaid. Real quick note, maybe their countable resources are $300,000. And maybe they're thinking, you know what, let me just go ahead and get this stuff out of my name, and then I'll have less than $2,000 and I'll qualify for Medicaid. So not only do you have to own less than these qualifying limits, but you also must have not transferred any assets out of your name in the 5 years prior to applying for Medicaid. So it doesn't do any good to transfer that $300,000 out of your name right before you go into a nursing home, because that by itself will render you ineligible for Medicaid, because Medicaid looks at any transfers that you'd made out of your name, any of those uncompensated transfers in the previous 5 years. So kind of an, oh, by the way, if I don't say it later, you never really want to, in most cases, you never want to apply for Medicaid unless you know you're going to qualify. Because the general rule is if you apply and get denied because maybe you did make some transfers of assets in the previous 5 years, there's a penalty period for having made transfers that may render you ineligible for more than 5 years from when you made those transfers. So just general rule here, never want to apply for Medicaid unless you know you're going to qualify. Back to our rules. If you're a single person, you have more than $2,000 of countable resources, bank accounts, CDs, stocks, bonds, real estate that's not your home, extra vehicles, land, then their Medicaid is going to tell you, I'm sorry, you don't qualify for Medicaid. If you do want to stay in this nursing home, we'd love to have you. You just need to write us a check for $10,000 every month. Some people think that if they go into a nursing home with assets, let's say you do go into a nursing home, you're 80 years old, you've got some Apple stock that's worth $150,000, you're single. Some people think the nursing home or Medicaid is going to go grab that stock. So, that's what people think. Are they going to, if I go into a nursing home, are they going to take my land? Or are they going to take the land I inherited from my parents? Are they going to take this stock account from me? So technically, they never take anything. They just say you're ineligible for Medicaid. So you're now put in a position where you have to sell the Apple stock to create the cash to pay the nursing home $10,000 a month. So Medicaid doesn't take assets; they render you ineligible, and then you just have to figure out a way to spend your money or convert the non-liquid assets into cash so that you can pay for that nursing home care. All right, now let's go to another rule. We talked about if you're single, and I realize if you're married, this doesn't apply to you. If you're single, Countable Resources, if they're more than $2,000, you don't qualify. If you're a married couple, no, there's two different rules for married couples, because the married couple rules, how much you can have depends on whether both spouses are going into the nursing home or whether only one spouse is going into the nursing home. We'll come back to that one. If you have a situation, the less common situation where both spouses are going into a nursing home and that they both require that level of care, they look at the assets of that couple, and if they have more than $3,000 of countable resources, they'll be paying, under our $10,000 a month example, they'll be paying $20,000 a month or somewhere around there. In order, they'll spend their assets down until they get those assets down to $3,000. Remember, they can't transfer any assets out of their name now because Medicaid penalizes them if they've made any transfers in the previous 5 years. So that's a tough one when you do have the married couple and they both go into the nursing home. Most people, realize it's really, really expensive. And so because you're paying double the nursing home rate. And then there's the example where you have a married couple, one spouse goes into the nursing home and one stays at home. So let's talk about what some Medicaid lingo is there. The one who goes into the nursing home is called the institutionalized spouse because they're having to move into a nursing home institution. The spouse who stays at home or doesn't go into the nursing home is called the community spouse. Doesn't have anything to do with community property, has everything to do with they're still living in the community. They're not moving into the nursing home institution. So the Medicaid eligibility rules are more lenient to that couple simply because the spouse who's still living at home has to have something to live off of. So again, rules vary, but most states have what's called a community spouse resource allowance. When one spouse goes into the nursing home, that's the institutional spouse, what's the value of the resources that community spouse is allowed to have, and the institutionalized spouse still qualifies for Medicaid. So that number for many states is 100 for 2024, $154,140. So let's apply some common sense to that. Mom and dad are not doing well, but you know what? Mom's doing okay. Dad's got to go in the nursing home. They have a house, they have a car, and remember, those are exempt assets. So for purposes of determining whether dad is eligible, Medicaid won't look at the house and the car, more on estate recovery later. But for purposes of dad's initial Medicaid eligibility, it's okay that they have a house and a car. So mom and dad's going into the nursing home, mom's staying at home. Their combined money, savings accounts, checking accounts, even their IRA is $130,000, which is less than the community spouse resource allowance of $154,140. So under that set of circumstances, dad would qualify for Medicaid would pass this asset test for purposes of Medicaid eligibility because Medicaid says the community spouse who's staying at home can have 154, 140. Okay, so we talked about what some of those qualifying limits are, and I've mentioned it a couple of times, but someone is also ineligible if they had made any transfers, uncompensated transfers, put assets in their kids' names or made some transfer of assets in the 5 years that led up to this Medicaid application process. All right. So now that we got that, if you've got some accountable resources, you're going to be ineligible for Medicaid. So let's talk now about what some of these kind of planning strategies are that people take advantage of. Essentially, and I will say, as the lawyers refer to it, there's pre-planning and there's crisis planning. We're really not talking in this live stream about the crisis planning. Crisis planning is, oh my gosh, grandma just broke her hip. She was doing fine yesterday and living by herself, no problem. But she fell and broke her hip, and now she's got to live in the nursing home for the rest of her life. That's what's called crisis planning. Crisis planning is difficult. And so there's typically very few just easy answers with crisis planning. Yes, can she go prepay her funeral? Maybe she can convert some countable resources into exempt assets. But we're not talking about that crisis planning. We're talking about the relatively healthy 65 to 70-year-old couple. They're like, oh my gosh, we're not getting any younger. We've got some ailments. We saw our mother go into the nursing home and she had to spend everything. We wouldn't want that to happen to us. Or 65-year-old couple says, you know what? When mama was alive, she put her land in our name and she went into the nursing home. The land was protected. We want to do the same thing. So let's talk about what some of those planning strategies are. Essentially, what this Medicaid pre-planning is, essentially, it's in one short sentence, it's transferring assets out of your name and waiting out what's called the 5-year look-back period. So that, in a nutshell, is what Medicaid planning is. Now there's a lot to what does it mean to transfer assets out of your name. And when I say survive or stay out of the nursing home or don't apply for Medicaid during this 5-year look-back period, there's a lot to that. So let's get into what does it really mean to transfer assets out of your name. So again, what people who attempt to artificially impoverish themselves in order to qualify for Medicaid, they're trying to get to a point where they have less than the qualifying limit, 2,000 single, 3,000 married couple, both going in the nursing home together, 154, 140 married couple, one spouse going into the nursing home, one staying at home. They're trying to get to that amount of countable resources or less, and no transfers out of their name in the previous 5 years. That's really the key to this Medicaid eligibility planning. So let's talk about you hadn't transferred any assets out of your name in the last 5 years. So transferring assets out of your name. So again, Fred and Wilma now, the Flintstones, they're getting a little older. Boy, I used to watch their reality TV show back when I was about 10 years old. That was about 40 or 50 years ago. I'm 58. And so Fred and Wilma now are really old. They don't look the same that they did in the old cartoon that was popular in the 70s, I guess. So they're like, boy, we're worried, we're worried we're going to lose our money, lose our house, lose our land. If one or both of us has a nursing home situation in the future, what should we do? They're like, should we just put all of our assets into our children's names? They're two kids, Pebbles and Bam Bam. And so they don't really like the idea of taking all of their assets and putting them in their children's names for some reasons that you probably already know. They don't like the loss of control of those assets, of taking everything they've worked for and just putting it in their children's names. They don't like the fact that if they did that, the children could make a mistake or get divorced or perhaps even get sued or just go on a spending spree. Maybe children have alcohol or drug problems, and so there's just potentially bad things that could happen when you just transfer all of your assets out of your name and into your children's names. So they don't really like the idea. They don't like the fact that they have some appreciated assets, and so by just transferring that appreciated Apple stock from their name into their children's names, they don't like the fact that the children would get that stock at a carryover basis instead of a step up in basis that the kids would get if the parents held on to it and left it to the children when the parents passed away, to ensure that all that capital gain goes untaxed. So they don't like the carryover basis rule of just transferring appreciated assets directly into their children's names. They don't like the idea of losing the opportunity to exempt 250, or in their case, they're married, $500,000 of capital gain from capital gains tax if they were to sell their residence during their lifetime. So there's a lot they don't like about the just putting all of the assets into their children's names. That's where trusts come in. So not just any trust, and I've heard a lot of people mistakenly say it's a revocable with an R trust, not okay to protect assets from the nursing home. And irrevocable trust is okay to protect your assets from the nursing home. That blanket statement is false. So yes, if you put your assets into a revocable trust, which many of you have done, I would say, when people go get their affairs in order, 95% of the people are transferring assets into their revocable living trust. And one of the main reasons they're doing that is assets in your living trust when you pass away. They avoid the court and attorney involved probate process. You create your Fred and Wilma trust. You name your daughter Pebbles as the trustee of the trust when Fred and Wilma pass away, and their home and other assets are titled in the name of their trust. When Fred and Wilma die, Pebbles the next day can disperse the assets out of the trust to the trust beneficiaries, as opposed to if those assets remained in Fred and Wilma's name, then those assets would be frozen when Fred and Wilma died, and there'd be court and attorney involved probate proceedings required. Judges would need to sign court orders ordering that those assets, which were in Fred and Wilma's name, be transferred to the appropriate heirs after Fred and Wilma die. So a lot of people set up these revocable living trusts to avoid probate. But number one no-brainer rule on Medicaid eligibility is transferring your assets to a revocable trust. When you do set up a revocable trust, it always says you can do whatever you want to with the trust assets while you're alive. And since you do maintain all of that control, Medicaid says if you go into a nursing home, you've got to consume or spend those revocable living trust assets. The revocable living trust offers you really zero Medicaid eligibility planning protection. They give you that avoid probate. So assets in your revocable living trust, they're still quote unquote in your name for purposes of Medicaid eligibility. They're out of your name for purposes of probate. So be aware of that. But even if you transfer assets, so most of the Medicaid eligibility planning that involves you transferring assets to a trust, it's always a particular type of irrevocable trust, and there's lots of Medicaid rules that attach to it. I'll start with the basic rule that under no circumstances if you transfer your assets to an irrevocable trust, it has to be set up in a way that under no circumstances can you have any access to that trust principal for the rest of your lifetime. There's other requirements as well, but if we're going to start with what are the requirements of an irrevocable trust that you have to meet in order to get that Medicaid eligibility protection, the first of many rules is under no circumstances if you were to review the terms of that irrevocable trust, under no circumstances can you have any access to that principal. A lot of people don't like that because they want to have that control. But so that's one of those things people have to decide. Am I willing to give up the control in order to get the Medicaid eligibility? More on that in a little bit. So these irrevocable trusts that people transfer assets to in order to get assets out of their name for Medicaid eligibility purposes, in very general purposes, it's typically an irrevocable trust for, I'm going to say, the children. So Fred and Wilma Flintstone set up an irrevocable trust. The beneficiaries of that trust are the two children, Pebbles and Bam Bam. When are those two children entitled to receive the trust assets? Depends on how it's written, but typically they're entitled to receive the trust assets after Fred and Wilma die. And in many cases, the trusts are written so that Pebbles and Bam Bam can receive trust assets if the trustee elects to make distributions to Pebbles and Bam Bam, perhaps during the lifetime of Fred and Wilma. Again, no principal distributions to Fred and Wilma. So the idea there is if Fred and Wilma may need those assets back in the future, perhaps the trustee could make distributions not to Fred and Wilma, but to Pebbles and Bam Bam, and maybe Pebbles and Bam Bam would voluntarily agree to pay for things for Fred and Wilma, even give assets back to Wilma in case Fred and Wilma need to go buy a new roof or a new car or something like that. So it's a complicated area. I'm just starting with the basics. But the idea here is, especially, part our live stream here is not only about, bank accounts, but investment accounts. Oftentimes parents, the Fred and Wilma Flintstones of the world, they don't want to lose this step up in basis that Pebbles and Bam Bam could benefit from if Pebbles and Bam Bam were to inherit the Apple stock or whatever stock when Fred and Wilma died. So very particular provisions need to be put into this irrevocable trust that, quite frankly, gets the assets out of Fred and Wilma's name for Medicaid eligibility, but keeps the assets in Fred and Wilma's estate for federal estate tax purposes. No big deal, because there's a $13.61 million federal estate tax exclusion amount. So if Fred and Wilma are doing Medicaid eligibility planning, they don't have $13.61 million. In fact, they certainly don't have the 2 times that, which married couples get $27.2 million of estate tax exemption amounts. So it's okay if we have the proper provisions in that irrevocable trust that, again, get the assets out of Fred and Wilma's name for Medicaid eligibility purposes. But for estate tax purposes, and perhaps even for income tax purposes, those assets still belong to Fred and Wilma. They're included in the estate of Fred and Wilma, which is fine because there is no estate tax. But by those assets being included in the estate of Fred and Wilma, Pebbles and Bam Bam will benefit from the step up in basis and all of the untaxed appreciation in those appreciating assets will forever go untaxed. I've done some other videos on step up in basis, carryover in basis. So if you don't understand it, you can go check some of that out. But really, a lot of the kind of sophisticated Medicaid planning is getting assets out of people's names, but doing it in the most tax efficient manner possible. Again, preserving the step up in basis, making sure the right people are taxed on the income, making sure the trust isn't taxed on the income at higher trust income tax rates, making sure the Section 121 exclusion, where married couples can exclude $500,000 of capital gain from the sale of their home if their home is sold during their lifetime, making sure all that is preserved. So I will say it's on that trust, perhaps, that Fred and Wilma are considering setting up. Another factor that can impact Fred and Wilma's decision whether or not to artificially impoverish themselves is there somebody who could be the trustee of that trust that Fred and Wilma trust enough to kind of do the right thing under circumstances. So all that plays into this Medicaid eligibility planning. Now, a few unique circumstances. I've touched on the home a little bit. Never said this directly, but let me give you the example. Let's say a single person, not married, just to keep it simple, a single person has a home. It's a $500,000 home. They have a car, doesn't matter what it's worth, $30,000. And they somehow, they were able to qualify for Medicaid because they only had $1,500 in their bank account. And they hadn't made any transfers in the previous 5 years. So now they're in the nursing home. They apply for Medicaid. They qualify. Even though the home's worth $500,000, Medicaid says it's exempt. We're not going to look at it. And it's, the value of it is under the necessary limit. However, and so many times people said, well, they didn't tell me about this when we put mom in the nursing home. They didn't tell me about this when we put dad in the nursing home. But it's in all of the paperwork that is signed off on when somebody applies for Medicaid is Medicaid has these estate recovery rights. So grandpa goes into the nursing home, he has his house, he has his car. The reason they let him keep his house is because if grandpa's condition improves, rarely does, but if grandpa's condition improves enough where he can leave the nursing home, then they let him keep his home so he'll have a place to go if his condition improves. But that's rare because once people go into a nursing home, they kind of come out feet first. Terrible joke, but I said it and it was on my mind. But that's why the home is exempt, because grandpa can have a place to go if his condition improves enough where he can leave the nursing home. However, they tell grandpa, right, we're not going to count your home. We're not going to count your car. You have $1,500 in the bank. That's less than the $2,000. Come on in. Medicaid's going to pay for the $10,000 monthly nursing home expense. Grandpa says, yay, fantastic. Grandpa's kids, grandkids, they throw a big party. Grandpa's eligible for Medicaid. But maybe what they realized, maybe they didn't, but it was in all the paperwork, that now when grandpa dies, and look, grandpa can't give his home to his kids now, because as soon as he transfers the home out of his name, it basically triggers him ineligible for Medicaid for the next 5 years. So he's got to leave it in his name. Great that he's got it. Great that he could go home if he got out of the nursing home, but he has his home, he has a car, Medicaid's paying the 10 grand a month. Everybody's happy. However, Medicaid has its estate recovery rights. So let's say grandpa lives in the nursing home for 4 years, and then unfortunately, grandpa passes away. What happens? Well, if the nursing home spent $10,000 a month on grandpa's care, and he lived there for 4 years, and then he died, not the exact number, but the nursing home or Medicaid probably spent around $480,000 on grandpa's care. So what happens? Well, Medicaid has estate recovery rights on assets that are in grandpa's estate. Grandpa has a $500,000 home or whatever it's worth. So Medicaid sends the letter to the family, says, yes, grandpa was eligible for Medicaid during the 4 years that he was in the nursing home and qualified for Medicaid until he died. Medicaid spent $480,000 on his care. Yes, we have a lien on assets that are in grandpa's estate. He has a home. Send us a check for $480,000. Again, Medicaid doesn't go take the home. They just expect to be paid by having grandpa's estate sell the home and then reimburse Medicaid for what Medicaid had spent on grandpa while grandpa was eligible for Medicaid. So again, more on that in the future. That home is a really unique circumstance. And so there's homestead exemptions we have to watch out for. I've mentioned a couple of times the exclusion of capital gain if the home is sold, and also preserving the step-up in basis for the kids if it's not sold during the Medicaid applicant's lifetime and it's left to the kids. So also know, I've mentioned it briefly, IRAs, most states, the IRA is like a bank account. It's like an investment in that it's a countable resource, and it is impossible for an IRA owner, for grandpa, for Fred Flintstone, you cannot transfer an IRA to a trust. The only way to get that IRA, and I'm talking about the traditional IRA, the traditional 401k that so many people have, and really the same rule applies to Roths. You just don't have the income tax consequence. But if you're going to get an IRA out of your name for Medicaid eligibility purposes, you've got to take a distribution from that IRA. And of course, if it's a traditional IRA, pay the income tax. Nobody likes to do that. But that's what you've got to do to get an IRA out of your name. You can't just transfer a traditional IRA to a trust and expect that to be some non-taxable event. You've got to take the distribution from the IRA, pay the taxes, and then if you do get that far, which most people never do because they don't want to, and quite frankly, I can't blame them, then those after-tax proceeds you could transfer out of your name to one of the planning options there. Okay, now there are special rules with IRAs. Some states, not a majority, but some states render the IRA exempt. But in many of those states, if you're taking, if that IRA is what's called in payout status, required minimum distributions, for example, the value of the IRA is exempt, but the distribution from the IRA is income, which must be spent on your care, particularly if you're a single person. There is some protection when you have the community spouse and the institutionalized spouse, and the community spouse is getting income. The community spouse typically is not penalized for getting income in their own name. But the income to the institutionalized spouse is all counted and must be spent prior to Medicaid covering that nursing home expense. Okay, so a lot there. And looks like we got some action here in the chat. So I'm going to do my best to hit that head on. Seems like the first line item on every live stream every time is good old Larry. Great to see you here. Larry from California, where they do have different Medicaid eligibility rules in California than all of the other 49 states. Let's see. Howdy, Braveheart, Terry, Michigan. Good to see you, Martin. When one beneficiary inherits a house from an estate, be certain not to overvalue the assets. This will allow the other beneficiaries to be paid an equivalent value in cash from the estate residue. So I think what you're getting at there is, let's say, dad says, I leave my estate to the 3 children equally. And either because it's mandated in the documents or the executor or trustee or the beneficiaries all agree, one child takes the house as part of their 1/3. And so I think what you're saying there, Martin, is, boy, if you're getting that house and it's really a $250,000 house, if you sold it, don't value it at $400,000 for future capital gains tax purposes, for example, because if you value it at $400,000 when it's really worth $250,000, your siblings are going to get $400,000 in cash off the top. So maybe that's what you're getting. And if so, good advice. Indiana's here. You're welcome, 99. Does VA disability count towards the 2? So income counts. VA disability income that's not an asset. The 2K is not an income, not a monthly income. It's what's the fair market value of assets that you own. So we'll have to get in another live stream this distinction between income and assets. And there are different rules that apply to income and assets. We talked primarily about the asset rules here on this live stream. Larry, I agree, Paul, it's scamming the system, pure and simple. I mean, like I said, Larry, you're calling a spade, which is what I like to do. I'm not crazy about it. Don't shoot the messenger. But the complaint I hear about the system is, well, geez, if you never save anything, the government's going to take care of you. If you are wealthy, then you obviously have enough resources to pay for whatever care you need. Fantastic. It's the middle class that gets trapped. I don't have a real strong opinion one way or another. I see all of the positions, and I'm just here to share with you the rules. But I get a good feeling when somebody says, you know what, let's just forget this Medicaid eligibility planning. I'm fortunate to have what I have. I've been careful with my money. Yes, I would like to get good quality care if I need it in the future. I don't really want to try to maneuver my assets to get the kind of care that the government provides for the impoverished. And we're probably going to see some comments here about the Medicaid quality of care is poor compared to the private pay level of care. Maybe there's some truth to that. Maybe there isn't. Maybe in a nursing home, even the staff doesn't know who's private pay and who's a Medicaid recipient. But I just know that the Medicaid level of care is generally substandard. So I do like when people kind of take that position that, hey, we got it. All right. Try to travel. What a great name. How about income from a $2 million lawsuit settlement? So, yeah, I mean, if you receive $2 million, not only from a lawsuit or from an inheritance, immediately now you have assets. So, for example, somebody goes into the nursing home at 70 years old and they meet all the qualifying standards. They have $1,500 in the bank and that's it. They're in the nursing home for 6 months and all of a sudden their 95-year-old parent dies and leaves them $500,000. Well, there's an obligation to report that. And so you'll no longer be eligible for Medicaid. You get kicked off Medicaid, your private pay until you spend all of that down and go back to having less than $1,500 in your name. So lawsuit, really same thing. What if you have a lot of investment real property? Can that be shielded from the pay down? Investment real estate is a countable resource, just like money in your checking or savings account is a countable resource. The people who try to protect those assets, get them out of their name, don't apply for Medicaid for 5 years. Or if you are, last minute, then you're going to be forced to sell that asset for fair market value and spend the money down before you qualify for Medicaid. So yeah, having land or real estate that's not your home, that's a real tough one for purposes of Medicaid eligibility. Atterbury Investment Management, great info you're sharing. Keep up the good work. Great, fantastic, Atterbury. Glad to be here. Great picture of you two and your little YouTube picture. Larry, 10 years ago in California from my mom, it ran $8,000 a month, and that did not include medication. So that was 10 years ago, $8,000 a month. Thanks for the comments, Larry. Mr. Old Clunker, I'd like to see your car, Mr. Old Clunker. If you own it, pay it, not the taxpayer's problem. Yeah, I can't argue with you, Mr. Old Clunker. Shane, hypothetically, grantor with a separate trustee and something is still suspicious or illegal. Maybe charitable remain was so. All of the stuff that I've talked about here. I mean, it's very clear. The government says you can do this. So, the government says you can transfer assets out of your name and still qualify for Medicaid. They don't argue with you. It's not suspicious. It's not maybe you'll qualify. So all we're talking about is just follow the rules. The government says you can do it, and there's nothing suspicious or illegal about it. I'm seeing Poppy So transfers. Yeah. I mean, so yes, if you have $300,000 in your name and you transfer that $300,000 out of your name, and then 6 years later you have $1,500 in your name and you had not made any additional transfers in the previous 5 years, you're going to be okay, because the transfer we're talking about here was 6 years ago, which is more than 5 years. So under those circumstances, okay. Richard Reed, what is funds assets are in a trust account? All depends, Richard Reed, on the terms of that trust instrument. I will suffice it to say, if that trust that the funds are in was not specifically prepared with the primary intention of protecting assets in anticipation of Medicaid eligibility, it's probably won't cut it. I heard they take assets after you're gone to pay back the money that they paid. Yep, we talked about that in the estate recovery that we just talked about a few minutes ago. Probably we talked about it after you wrote your chat there, but I like the way you're thinking. I can understand why the elderly go out on their own accord, sadly but true. I will say I was involved in a circumstance there where a gentleman, he told me, he said, Paul, if I ever get to that condition, I'm not going into a nursing home, and I'm not going to force my family through that, and I'm not going to make them incur that expense. And by no means am I suggesting anyone do this, but he did, commit suicide, and just a terrible situation. Hope I never see that again. So Medicare doesn't pay for a nursing home. Great question, Poppy. If you go directly from a hospital, I think the rule is if you go into a hospital, which Medicare pays for hospitalization, all the lab tests, doctor visits, and you're in a hospital for 3 nights, and then you go into a nursing home for rehab, and then you stay in the nursing home, Medicaid pays for a very short stay for that rehab if you continue to get rehab. And then after that, you're on your own. Medicare doesn't pay for the nursing home. So if you don't go to the hospital for 3 nights in advance of going to the nursing home, then Medicare doesn't pay for any of the nursing home, and so you're on your own, or at least Medicaid will apply. There you go. And Maria, you're answering my question. Medicare will only pay for so many days. I don't know the exact number, but it's short term. Maria, 28, you and I think a lot alike. Great minds think alike. The beneficiary does not have the asset until after the owner dies. So let's see here. Ed says, Tom, Ed, Mr. Rabley, longtime listener, first time messenger. Great to see you on the chat, Ed. I get a shout out. I don't get many people, every night are kind of telling me hello or maybe giving me the Ann emoji with the happy hands. Larry's on there every time. So Ed, keep them coming. Diet, we had an estate attorney tell a family member who is already on Medicaid that there would be no Medicaid recapture if she needs to go to a nursing home. Is this correct? Well, regardless of what the attorney told you, when you say you have a family member already on Medicaid, just take a look at all those forms that were signed as part of the Medicaid application. Maybe you didn't read it, maybe you glossed over it, but it was really clear in those forms that Medicaid has its estate recovery rights. So kind of being able to say, well, we didn't know, it just doesn't work in our world. So Grandpa just got a loan. Okay. Reverse mortgage. Not going to go there. I see those are just some comments. Maybe that's some people talking back to each other. How can I put my house in the trust and have the proceeds given to someone? What proceeds? The proceeds from when the house is sold at some point? I'm not sure what the question is. I need to ask more questions. Never seen a high level of quality nursing home care. I think in blank statement, y'all can back me up in the chat, but I think in most cities have a bunch of nursing homes. A bunch might be 10, a bunch might be 50. And in most cities, the majority of the nursing homes have both Medicaid recipients and private pay recipients. And then it seems like in each city, there's a small handful of nursing homes that are exclusively private pay. And I would say generally, perhaps the level of care in those exclusive private pay nursing homes likely to be higher than the level of care for the facilities that have both Medicaid patients and private pay patients. Love to see in the chat other people share their thoughts there and their experiences. Ed says, my mother is 80 and in failing health. If she takes out HELO, home equity loan on remainder of equity to upgrade home to accommodate medical issues and spends funds reasonably, problematic? Perhaps not, as long as she didn't make any uncompensated transfers. So people spending assets now, but you've got a loan out there that has to be repaid at some point. So HELOC, home equity line of credit. So real tricky with the home stuff. Paul, what about income you receive after qualifying for Medicare? You probably mean Medicaid. Can you keep that or have to pay it for your care? Short answer is you have to pay it for your care. Single person has pension, Social Security. Let's say it's $5,000 a month, but they have no assets. They apply for Medicaid. They qualify. The quickie answer is nursing home costs $10,000 a month. They always have to assign their income to the nursing home. So the nursing home gets that, and perhaps Medicaid would pay the balance between their income, which gets assigned to the nursing home, and the cost of the care. It's the general rule. Can I transfer assets jointly owned by me and my wife to just my wife? Is that sufficient to prevent Medicaid recovery? Maybe it depends on the state. There is no penalty on assets that assets transfer to each other. Any other transfers fall under this uncompensated transfer rule, but you can transfer assets from one spouse to another. How much you charge for a lifetime investment appointment or just upfront? I don't really know what you're getting at there. Try to travel. I don't know. Sorry. When the house is sold, can I name a beneficiary? Yeah. So I guess what you're saying is if your house is in a trust and down the road, the house is sold. There are beneficiaries of that trust, and our Fred and Wilma example, their two kids, Fred and Pebbles and Bam Bam, were beneficiaries of that trust. So you can direct who's entitled to that asset, whether it's a house or other assets. I'm just kind of speculating as to what you're asking. Okay. Maria's talking to Tim. What if your wife has to go in the nursing home first? Good question. So you're asking Tim. So I'm going to let you and Tim exchange about that. So, all right, good one there. Thanks, Sue, for saying good stuff. Thank you. Make sure if you already subscribe, if you typed in the chat, you're already subscribed, or if you're just a listener and not a chatter, make sure you've subscribed. Make sure you like the video. That helps out the thing. And I see there's a place for you to do a heart and all that. So all that, I guess YouTube picks up on that and sees that maybe people liked it. So throw us some hearts, throw us some good stuff, throw us some emojis, and we'll see you on the next live stream. We've got some more coming up. Y'all have a great night. Thanks for staying with me through all that time.